everyone. Welcome to the lecture for Legal Studies Units 3 and 4. My name is Sunny. I'm really excited to be delivering this lecture to you all today, and I hope that you find it particularly useful in preparation for your upcoming Legal Studies exam. So on this slide, you can just see some of the free resources that HR Notes has to offer to further aid you with your studies, as well as HR Notes Plus. But let's get straight into the September lecture. So, as I mentioned, my name is Sunny. I'll first begin by introducing myself. I graduated in 2021 with an HR of 96.70. My highest study score was in legal studies, which was a 47, and I received study scores of 40 plus in my other subjects, which included English, literature, English language, general mathematics, and psychology. And I'm now currently in my last year of completing a Bachelor of Paramedicine degree at Monash University. So on this slide, you can see the layout of today and what we're going to be doing. So it's basically just split into two blocks. We'll be doing Unit 3 revision and Unit 4 revision as well in the second part of the lecture. So there is going to be a lot of content, and we'll have to move through really quickly to make sure that we can cover all of the main concepts because legal is a very content heavy subject. So feel free to use the live chat Q&A that's attached to the lecture to ask me questions live as you're watching. If you need clarification or on anything, if you need additional exam tips, we do have the study tips section will be at the very end of the lecture where we'll be talking more specifically about exam prep and what you should be doing. But feel free to use the opportunity to ask questions live, and I'll be able to see all of you guys' questions and reply as you're watching. So let's get right into it. So the first thing that we need to address is the importance of the study design as a key resource for your exam preparation. So you should have it printed out and sitting on your desk while studying, have it highlighted and annotated, particularly what's important for each area of study. There are the key knowledge dot points, which tell you exactly what you need to know and what you will be assessed on. This helps you to focus your study and make sure that you're not learning unnecessary information from your very content heavy textbooks, and you are studying only for what is going to be on the exam. And then the key skills dot points tell you what kinds of questions you might get from the actual content on the exam as well. So this tells you exactly what I just said. The key knowledge dot points tell you the concepts that can be assessed. Nothing outside of these will be assessed. So this is all you need to know. And the key skills dot points essentially tell you the types of questions. What else I really recommend using are the exam reports and past VCA exams. The key to revision for legal studies and exam prep is step one, learn all of your content and revise everything you need to revise so that you can do questions closed book under timed conditions. Otherwise, they serve no purpose or benefit. So that's step one, and that's what you should be doing or should have done by this stage. And then the key is to do exam questions from past exams. Yes, the study design has changed since last year, but you will find that it has changed very little. In fact, some things have been omitted, nothing has been added. So most past exam questions, all the way from 2018, you will still be able to do with the new study design, and therefore you have plenty of past exams to practice. So do as many of them as you can under time conditions, and then mark yourself against the examiner's report's feedback to see how you fare in terms of getting all of the marks. Reading examiners' reports is extremely important as they tell you what you need to do in order to get full marks for questions, and they also attach exemplars from high scoring students for each question. Those high scoring responses are the perfect study aid that you can use to figure out how you may better structure your responses, the kind of length expectation, vocabulary, use of terminology, really good points to raise. So you should be annotating them and taking on board things from them as well to aid your own writing and structure and strength of points that you make on exam questions. So there is an examination report for every single year. So, like I said, you have many years of resources to work with, um, and you should be marking yourself against them. They also have mark averages and tips on how to get full marks. So you can see where students average, and this is usually poor on the holistic responses that are marked. So extended questions that are 6 marks or more, assessors will give a mark based on the quality of the overall response rather than looking for something extremely specific, like a specific point you had to make or anything like that. So to get a good mark on a holistically marked question, that means you need to write a really perfect response. Now, in order to see how to do that, that's where you go. You go to the examiner's reports and you peruse them, see what they said students needed or were missing for those full marks, and look at the exemplar response that they've provided. Additionally, the points to bring up in your answers will also be provided. And the high scoring responses that are structurally and in terms of strength of points that are raised, perfect. Okay, so the first thing that we're going to go to is our unit free revision, starting with the criminal study design, and then we'll go to civil. Be really aware that questions on the exam often come up that make you compare an aspect of the criminal versus civil justice system. So you don't know them just separately, but you need to know them so confidently and so well that you should be able to answer those questions comparing concepts within criminal versus civil. And that is a frequent topic for 10 markers as well. So, for instance, a 10 marker could be um, the does the do civil remedies achieve their purposes better than criminal sanctions? That's actually one that has come up, for instance. So obviously that's going to be really challenging to answer if you're not confident relating criminal versus civil and comparing them to each other. So here we see the key knowledge dot points. Happy for you to pause, and if you're not super familiar with the study design yet, you can read through what you need to know and what is going to be assessed, but all of it is really things that we'll cover anyway. And this is the key skills, the types of questions. So first of all, the revision of the principles of justice is what we need to start with. So I have here that these concepts are crucial. They underpin almost every piece of content in Unit 3, and you need to have a solid understanding of each of them. So be able to define them, but not just define them, but knowing what falls under each principle. Still, at this stage, I see students raising a point for strengths or weaknesses about and linking it back to the wrong principle of justice due to a lack of foundational knowledge about how they differ and what exactly they mean. And access is the one that students don't usually get wrong, but I see fairness and equality being confused in points still very frequently. So fairness is all about being impartial, having just treatment within the courts without any discrimination or favoritism, and everyone is treated the same way in an unbiased manner despite personal characteristics. And equality suggests that all people should be completely equal before the law and have the same opportunities as anyone else. Access means everyone should be able to access information about the legal justice system and access the justice system itself, including being able to initiate a civil dispute or being able to seek out information about the courts or to apply to get a duty lawyer appointed or to get funding if the person has limited funds and they're going on trial within the criminal justice system, for instance. So, what goes under fairness? So, fairness refers to fair processes and a fair hearing in a broad manner. This means everyone understands what's happening within the courts, particularly in their case as an accused person. We're able to navigate and understand proceedings. Everything is completed in a timely fashion. There are no undue delays to cases being heard, and everyone has having adequate legal representation. So, also, if you have limited income, still being able to get a lawyer, everyone having the opportunity to present defenses to crimes, everyone knowing what evidence specific to the case is being brought. So during pretrial procedures within the criminal justice system, for instance, um, the prosecution has to disclose all of the evidence that will be brought in court against the accused. And this is more likely to make them decide if they still want to proceed with the trial or they would like to just plead guilty because there's little chance of being found not guilty at the end of the trial. Same in the civil justice system during the process of discovery, which occurs during a civil proceeding. The plaintiff and the defendant have to share the evidence that they are going to bring against each other. Everyone has the opportunity to disprove the respective counsel's case, and we know our barristers or lawyers and the prosecution go up against each other and try to achieve exactly that. Everyone also has the opportunity to appeal if there are reasonable grounds to do so. Now, notice the difference with equality. So, fairness is different in that if someone has a disadvantage, this disadvantage is amended. So, see how all of these kids, even the short kid, can see the baseball game. So, the whole idea would be then that, let's say, one person doesn't have a lawyer, so they're given these boxes to make them more equal in the justice system in the provision of duty lawyers and legal advice by Victoria Legal Aid, for instance, to make them not subject to discrimination and not subject to a risk of an adverse outcome in trial that is unfair simply because they didn't have the resources to hire legal representation. It should be provided to them. Equality, on the other hand, everyone is completely equal. So if you have a disadvantage, you're stuck with that disadvantage and nothing is done. So this is a very different idea. It's all about everyone being the same. Not necessarily at a disadvantage though, but everyone being the same. So think about those things that don't achieve equality as well, where someone is unfortunately, subject to some kind of inequality within the legal justice system. So it's all about being treated evenly. So everyone has an equal opportunity to present their case. Court proceedings and processes are formal for everyone, and the same rules, strict rules of evidence and procedure apply to everyone. Um, Processes and persons who make decisions don't have any bias or association with the person, and no one is treated at an advantage or disadvantage. Everyone is equal. So don't confuse equality and fairness. So here is a comparison table showing you fairness versus equality. So fairness would imply that the degree of punishment or sanction imposed should reflect the gravity of the offense. So, for instance, severe penalties will be given for severe crimes and the other way around, vice versa. Um, Everyone is subject to strict rules of evidence and procedure to ensure that the right to a fair trial is upheld. And if people are treated differently, it's due to application of the law, such as considering aggravating factors, mitigating factors, victim impact statements, whether a guilty plea was provided or not. So it's always from application of the law, not because of personal characteristics, not because the judge pities someone, for instance, or likes the uh, likes the accused better than the victim. You know, that's not the there's no bias in fairness. So that's important. Fairness is associated with no bias. Now, equality, so things like being deemed equal in status, rights, and opportunities, and laws being applied equally to everyone, and not providing any exceptions or discrimination based on personal attributes. Everything is the same for everyone. Okay. Now, lastly, access. This is the one that students get usually quite easily. It's all about understanding, being able to seek out information, being able to pursue claims within the legal system. So everyone should be able to understand their legal rights, and that includes things like when is something considered a civil wrong? When can I try to seek compensation for that? And how and where? And how much money would that cost and which court it's going to go to? So being able to find that information. Things being accessible means they need to be affordable enough for everyone as well. So if I'm trying to initiate a dispute, but it costs so much money to do so, that's not achieving access. In fact, the opposite. But for most people, it is quite accessible because, as we know, we have VCAT for civil disputes, which is more affordable and faster. And if it's a minor dispute within the magistrate's court, filing fees to actually initiate a civil claim won't be so much. It's affordable enough for most people. This also considers that everyone should be able to access information, bodies, institutions, things like VCAT, community legal centers for information and advice. And everyone receives materials pertaining to criminal cases, processes, and outcomes, including that sharing of evidence that we talked about between parties. Now, this just lists you some more examples of which institutions also as well predominantly achieve each principle. So feel free to pause and consolidate, but we will move on to very criminal justice specific things. So the key concepts that you need to know and potentially contrast between criminal and civil are the burden and standard of proof. Now, the burden of proof is who has to prove a case in court, who actually has to prove the other person is responsible for whatever happened. Okay, that is the prosecution on behalf of the state in Victoria that has the burden of proof because they are bringing charges against the accused person. So this is fair. The accused person, which is literally accused of doing something wrong, should not have to prove that they are not guilty. It is up to the prosecution to prove that they are. Now, the standard of proof is essentially the level of evidence that's required, or the degree of evidence that's required to prove a case in court. In criminal cases, that means beyond reasonable doubt. Because being considered a criminal and being convicted of a crime has such dire implications to a person's life, employability, and potentially dire sanctions as well, including imprisonment, we have a very high standard of proof compared to civil cases, which is beyond reasonable doubt. And you need to be able to explain exactly what that means. This means that there should be no doubt by a reasonable person. We assume someone being a reasonable person. There should be no doubt as to whether or not the offender did commit the crime or not. We should be absolutely certain when we convict them. That means there's no circumstantial evidence, there's no gaps that need to be filled, and there is no doubt that they definitely did it. Okay. So it's kind of in the name. Now, we also have the concepts of the rights of the accused and rights of the victims. So the ones that you need to know, the right to be tried without unreasonable delay, the right to silence, and the right to trial by jury. And I've listed there which legislation protects which is not a must know, but some students like to put acts and stuff in responses to show off a little bit. I know I used to. But let's go into them in a little bit more detail. So the right to be tried without unreasonable delay refers to the notion that an accused person should have their charges heard in a timely manner, and delays can only occur if they are reasonable. So consider this. You are someone accused of a crime, and there's crazy court backlogs to the point that you're waiting for your trial for years, and you haven't been granted bail, but you didn't even commit the crime. So you've been sitting in jail for years just waiting to be tried. This is exactly why this right exists to prevent things like that from happening. Now, however, where the courts have ability to do whatever they want is this word reasonable. Now, it's up to the courts to deem what is a reasonable delay and what is an unreasonable delay, unfortunately. So, the ability of this right to achieve fairness and limit delays is often very, very limited because courts can say a delay is reasonable for whatever reason that may be. Um, but it acknowledges that delays will occur within the justice system. They just simply cannot be logical or unreasonable. They cannot be super excessive. And even this is a right that is often applied after the fact. So let's say, yes, someone being held in custody awaiting trial is eventually found guilty of the crime when they eventually have their trial. But they've been sitting in jail for a really long time waiting for this trial. So oftentimes, uh, retrospectively, courts may take that additional time off of their total sentence to essentially indicate that they've served part of it because they've been sitting in jail while waiting for trial. Another one is the right to silence. This one is really straightforward. You see in the media all of the time, especially American media, someone getting arrested, and then the police officers read them their rights and also inform them that they have a right to silence. Essentially, they're allowed to remain silent when being questioned by authorities about anything, about what happened, the identity of people involved, what roles that person played to avoid themselves incriminating themselves, and they can even choose to not say anything at all. This is the first thing that is said to someone when they're getting arrested because we need to make sure that they know about it straight away, that they have this right to silence. And that's why this occurs. And lastly, the trial by jury, which involves members of community being impaneled, randomly selected from the electoral roll, from enrolled citizens that have to vote, and they have to listen to the facts of the case and determine the verdict of guilty or not guilty, or liable or not liable within the civil justice system. Jury within the criminal justice system involves 12 members, whereas in civil, they're very rare. Only if one party has elected to have a jury, and they usually have to pay for it as well. And they will have only 6 members. They're only accessible to individuals charged with an indictable offense, which is in Victoria, that's enforced by state level legislation, but in Commonwealth level, so for crimes that fall under the High Court, Section 80 within the Constitution includes the entitlement for trial by jury for Commonwealth indictable offences, but not state level. So, state level legislation protects the right to trial by jury in the various states of Australia, including Victoria. That means it could be legislated away because it is not in the Constitution. The Section 80 provides for trial by jury at Commonwealth level for Commonwealth trials. Now, the rights of the victim include the rights to give evidence as a vulnerable witness, to be informed about proceedings, and to be informed about the likely release date of the accused. And they're all stated in the Victims Charter Act 2006. So, the right to give evidence as a vulnerable witness allows people that are considered vulnerable, which can include many different things. Simply, it could just be minors, people under 18 years old, people with cognitive impairment, people with disabilities, people with mental health issues, people who are victims of domestic or sexual violence, and the trial is against the perpetrator or supposed perpetrator, as some of the examples of vulnerable people. But these vulnerable persons are allowed to access certain provisions in order to protect and support them when they give evidence in court as a witness, which is obviously a very challenging to do if any of these factors affect you, hence you're vulnerable. So some of these provisions can include a support person. For a minor, that could be having a parent with them in the courtroom, well, to support them while they give their witness statements. Judges or legal representation could disrobe and take off their wigs. Again, that's very suitable for kids or people with some kind of disabilities or cognitive impairments, or even giving evidence through short circuit TV. So you don't have to be in the courtroom with the accused or the perpetrator. who you has caused you trauma, and you don't want to be in the courtroom with them, and it would be too difficult to deliver your account that way. Um, so some other examples of what it could involve. An animal recently, animals have been introduced. Support animals can be within the court with vulnerable witnesses. The court being close to the public, so no one else is there while you, as the witness, have to give this statement. And we do have to apply to courts to make these arrangements, and they will consider if you are vulnerable or not, and what kind of um, arrangement you may be granted. You don't need to know the criteria about that, though. Now, the right to be informed about proceedings means victims of crime and witnesses can be entitled to information about the investigation of the offense and prosecution of the accused. They will have also, as part of that court processes, be explained to them, and how long everything's going to take, and how an outcome is decided, and things like that. So in this situation, the prosecution usually sits down with the victim and outlines what is occurring within the case, and this will happen multiple times as the trial of the accused progresses. So they may, for instance, inform the victim that they plan to proceed with a plea negotiation and see if the accused will enter into a guilty plea. If the victim wanted their day in court and to see retribution happening to the accused and being able to say how their actions impacted them, they might be quite upset about this. So, of course, the prosecution, even though they're not going to change what they're doing, they at least have to sit down and inform the victim if something like this is happening. But this is going to be involving many, many other things. And here is the specific criteria of what a victim must be informed of. Having like 1, 2 examples of what specifically a victim needs to be informed of will suffice for your questions. So you don't need to know all 4. But the specific charges against the accused are made known to the victims. Um, if no charges are made, so the person is acquitted and the trial doesn't proceed, the reasons for doing so, such as we didn't have sufficient evidence to continue with the trial. Also, how the victim can find out the date, time, and place of any hearings or the trial, if they do choose to attend the trial, and outcomes of the trial, of course. So, is the accused found guilty or not guilty, or was it an acquittal? Has there been insufficient evidence to prosecute them and they get off scot-free? And details of any appeal made by the accused. They would know if the accused initiated an appeal even before it was decided if the appeal had grounds and a retrial would happen or not. Now, the right to be informed about a release date of a perpetrator is only something that is afforded to certain victims of crime. There is specific criteria for this. There is the victims register, whereby specific victims that will have this right must be listed and named. And this only applies to specific offenses, such as those involving assault, physical or sexual, or injury punishable by imprisonment, so causing someone serious or life threatening injuries. Um, People on the victims register will need to be informed at least 14 days before the release from prison of the offender that they are going to be released, so they can mentally prepare, or even physically, if they think violence that will recur, and they need to make sure that person will not be able to find them or even move and stay around somewhere else for a while. So this is to protect victims. So it's a criteria that we must be on the victims register, but there are some additional things we'll be informed of. Not just the release date, 14 days before they are released, but also the entire length of the prisoner's sentence when they're found guilty, including their possible earliest release date if they are released on parole. And if they are released early on parole, the victim must be informed of that as well. And if the prisoner escaped somehow, they would also be informed of that as well. Okay, progressing on to our institutions. So we have Victoria Legal Aid, which we talked about just a little bit already. But knowing the purposes of VLA, it exists as a government funded organization, which is always chronically underfunded, with many reforms still ongoing and existing, and recommended reforms about raising VLA's budget. But it's dedicated to providing mostly legal representation in the form of duty lawyers, which work essentially to represent accused persons in trial that cannot afford legal representation. And they also provide legal aid in the forms of legal advice, grants of financial assistance, so some money potentially being provided, and also free information being provided about the court system and procedures, all to accused individuals in Victoria specifically who would otherwise be unable to access these services. It's only for those of low socioeconomic status and low income. And predominantly, Victoria Legal Aid assists within the criminal justice system, not within the civil justice system. Its scope in the civil justice system is very, very narrow. So, predominantly, they do assist accused persons within the criminal justice system only. Um, so, obviously, it aims to predominantly achieve access and reduce disparities in access, providing improved access to justice and remedies as well, and legal aid at a low or reasonable cost. So these are the roles you must know and be able to explain and give examples of: free legal advice, free legal information. The difference is legal advice will be case specific, um, whereas information is available to everyone, even on their internet websites. Duty lawyer services, free of charge lawyer to represent you in trial, and grants of legal assistance, which we said might just be giving someone a sum of money. Um, then we also have community legal centers, which are different in the sense that they're not government funded. They are essentially legal services, small pop up legal services that exist within different suburbs and towns and rural or regional areas, sometimes within Victoria as well. They're accessible, efficient, low cost, and provide general advice to the public on a wide range of criminal and civil matters. Rarely do they appoint duty lawyers, which is how they differ from VLA, but they will have some volunteer lawyers working for some of them, and those may be able to provide actual legal representation for trials. Um, but they do provide a lot of legal advice and a lot of free information. There are also two types. There's a generalist community legal center, which is based on a geographical area that we might be able to seek out their assistance. And there are also specialist ones that might be assisting with only certain types of the law or only assisting certain groups of people, such as Aboriginal and Torres Strait Islander people. Another thing you need to know about is plea negotiations. So, defining plea negotiations, they have to be initiated on behalf of the prosecution. There are discussions where the prosecution and the accused work out an agreement to the charges laid. It's always the prosecution trying to get the accused to plead guilty to avoid a lengthy and expensive trial, saving time, resources, and money for the courts. In exchange for pleading guilty, the accused will also receive what's called a sentencing discount and likely serve a shorter sentence to whatever imprisonment term they may have gotten had they chosen not to plead guilty. So the benefits of pleading guilty are great. And they also prevent further harm to victims and witnesses because they have the certainty that the accused definitely committed the crime, that everything is dealt with, they're going to get the punishment they deserve, and they don't have to go through a traumatic and prolonged trial. Um, Importantly, with plea negotiations, you need to be able to discuss their appropriateness. So, this depends on a few factors: the seriousness of the crime. If the crime is particularly heinous and horrible, the prosecution may not want to have plea negotiations because a reduced sentence for that offender is inappropriate and they should be punished to the full extent. The strength of evidence is another factor. The stronger the evidence we have against the accused, the more likely it is that we're just going to prove they're guilty at trial anyway. So there's no point to plead with them to plead guilty, because we're definitely going to be able to show that they did it and they'll get the full punishment. If the accused is willing to cooperate and plead guilty, plea negotiations are appropriate. And when they cooperate, they might disclose key information about the crimes, including revealing any co perpetrators, where a body was buried, these details that will help the investigation tremendously. The views of the victim need to be taken into account if they want their day in trial and see retribution being achieved, or they just want to get it done and over with. And possible adverse consequences of a full trial need to be taken into account as well. This is the court hierarchy. We're not going to spend time talking about this. You need to know, but for both criminal and civil, because they differ, what type of disputes are heard in each court, both their original and appellate jurisdiction, so what kind of appeals can be heard, if any, and be able to give a few examples. Also, if an appeal is initiated within one court, where would that appeal go? So you're required to know these things, and they can make for some stimulus-based questions. Remember, it's different in the civil justice system, and even the appellate jurisdictions are different, and where appeals will go, they slightly differ. So the reasons for a court hierarchy you need to know and be able to discuss in the criminal justice system are appeals and specialization. Appeals suggest that if there are grounds for an appeal, a party who is dissatisfied with the decision, whether it's the accused or the prosecution, may take the matter to a higher court to challenge the decision. They can file for an appeal, and if they are deemed to have had reasonable grounds to do so, that will be accepted, and they will have a trial again in a higher court. Specialization refers to the same types of cases being heard over time and time again, because the courts have the court hierarchy, and judges will hear specific types of cases depending on which tier of the core hierarchy they work in. So therefore, they will develop their own areas of expertise or specialization, ensuring more fair outcomes for accused persons within the criminal justice system. For instance, magistrates, courts, judges would be experts in minor crimes such as petty theft, because that is what is part of the jurisdiction. Next up, you need to know the responsibilities of personnel within the criminal justice system. So these include the judge, jury, and the parties and their legal representation as well. Now, some of the roles of the judge: they need to manage the trial, ensuring everyone is adhering to strict rules of evidence and procedure, give directions, so instruct and set deadlines for the parties, such as the deadline for submission of evidence, limiting cross-examination time. And they will also clear up ambiguities made in submissions by parties and check the admissibility of evidence, whether it fits the standard criteria and whether it is relevant to the trial or not, and therefore should or should not be presented at trial. They will have to instruct the jury and guide the jury, and they will also hand down a sentence. Additionally, if it's not a serious crime, and there is no jury appointed, because juries are only appointed for indictable offenses in the criminal justice system, the judge will also decide upon the verdict of guilty or not guilty, but only when there's no jury appointed. Now, juries have some roles. They have to listen to the instructions of the judge. They have to be objective, deciding the case based on facts alone. They have an obligation not to seek out information about the case or talk to anyone about the case, and abstain from seeking information on media about the case. They have to listen to and remember evidence, and make notes of the evidence, and they have to deliver a verdict, which has to be unanimous for most serious offenses, meaning all 12 of 12 jurors agree, but a majority verdict can be accepted for certain offenses, so 11 out of 12 agreeing on guilty or not guilty. They also have to select a foreperson that is a jury member, that communicates with the judge on the entire jury's behalf, such as in delivering the verdict. Now, our other personnel are legal practitioners and parties who have very similar roles. So, legal practitioners are lawyers. They have certain obligations they have to abide by to the court, such as to act ethically in accordance with the law, to not misrepresent the law or their client's case, and no deception. They also have to present their client's case in the best light possible to their ability. They also have to inform the accused of their legal rights. They have to provide recommendations as to what they should do within the trial and how they should do it, but ultimately allow them to make their own informed decisions of how they want their case to be presented. The parties include the prosecution and the accused. They will either do these roles if they don't have a legal practitioner, and if they do have a legal practitioner, all of these tasks will be conducted on behalf of them by their lawyers, okay? So they give an opening address to the jury or judge summarizing their case. They have to present their case to the court in an open, diligent manner. The same overarching obligations, which is the first dot point about legal practitioners, they also have to abide by. They also have to give a closing address similar to an opening address where they summarize everything. You know, if it's the accused person, they will summarize all the reasons why they should not be found guilty. If it's the prosecution, they will summarize all the reasons why they should be found guilty. Um, and they make submissions about sentencing. So, for instance, if the accused should be found or should not be found guilty and why, the main reasons why, and how severe that punishment should be as well. Now, the purposes of sanctions, very helpful little abbreviation you can use to try to remember them, Dr. DPP. And there they are. So, the 5 that you need to know: deterrence, denunciation, rehabilitation, protection, and punishment. Deterrence and denunciation are often confused, so make sure you don't confuse them. Deterrence is a process by which sanctions discourage the offender. If they discourage the offender, it's achieving specific deterrence, and others in the community from committing similar offenses of a similar nature. If it's discouraging the broader community, it's called general deterrence. Denunciation means to denounce, to disapprove. So, this is the process by which a court demonstrates community's disapproval of the offender's actions. This will be done through the judge's comments at the end of the case, and also by imposing a more severe or prolonged sanction. Rehabilitation is designed to reform an offender to prevent them from committing crimes of a similar nature and getting stuck in the criminal justice system and, reduce recidivism, reduce reoffending. This is really the only purpose that results in a less severe sanction being imposed, with the hope of rehabilitating the offender. This is the only one purpose of its nature. Protection aims to safeguard the community from an offender. So, for instance, imposing a longer prison sentence for a murderer to make sure that they are held in custody by the state and the community is protected from them. And punishment aims to penalize the offender, preventing them from reoffending, and will also result in a more significant sanction being imposed. Now, the types of sanctions include fines, which are the lowest sort of sanction, with the least impact. This is an amount of money ordered to be paid by the offender to the state of Victoria. Fines do not rehabilitate offenders because it's just a sum of money that needs to be paid. Now, CCOs are supervised sentences served in the community with special conditions. The judge can adjust these conditions based on the person and what they've done, and each set of conditions for every person that's an offender may be different. It can include things like curfew, alcohol exclusion, being banned from visiting certain venues or seeing certain people, etc., an ankle bracelet. This one achieves rehabilitation because usually there is community work attached, and also attending counseling, regular drug testing, and meetings with staff at the CCO centers to talk about their progress and how they've been progressing on their goals and conditions. Now, imprisonment is the most severe sanction, removing the offender from society for a stated period of time and placing them in the custody of the state prison. So, for each sanction, you need to be able to discuss how each purpose is achieved or is not achieved. So, have a table like this, hopefully with many more points than this, but you can have a read through um, this table as well in your own time. Now, we said already what the factors considered in sentencing are. Essentially, these factors will result in a more serious or a less serious sanction being imposed. Um, so these include aggravating factors. These are the circumstances of the crime, offense, or victim or offender that increase the offender's guilt and severity of the crime, leading in a more significant sanction being imposed. Mitigating factors are the opposite. They decrease the offender's culpability and the severity of the crime. Guilty pleas are required to result in a less severe sentence by the Sentencing Act if the accused pleads guilty. They also, however, consider the stage at which the plea was entered. So the earlier you plead guilty, the more of a sentencing discount you will receive, and vice versa. If you plead later in the trial, you will not have a significant reduction in your sentence as much. Victim impacts are written or oral statements provided by victims detailing how they have been impacted by the offender's actions. And the judge will consider the impact upon victims based on their statements to determine if a more or less significant, again, sanction is needed. So that's everything for criminal. Now we'll do the same for civil. Similarly, you can see your key knowledge dot points here and your key skills, so the types of questions. Let's compare. The burden of proof, which is the obligation of a party to prove a case in court, rests with the plaintiff. That's because, similar to the prosecution in criminal cases, the plaintiff is the person initiating the civil claim, suggesting that the defendant has done something wrong to them and breached their civil rights and has to pay. So, therefore, they have to prove that they are responsible, the defendant. The standard of proof, the level of evidence that's required, is on the balance of probabilities, which is a much lower standard of proof than in criminal cases. Simply, this means the judge will decide which version of events is more likely to have happened, that told by the plaintiff or that told by the defendant when determining liability. The other concept you need to know about is representative proceedings or class actions that occur within the civil justice system. This refers to a case being brought by 7 or more people, but there must be at least 7. Make sure you remember that. That's very important for questions. And it is brought on behalf of really one plaintiff, referred to as the lead plaintiff. So the group of plaintiffs will choose one plaintiff as the lead plaintiff to actually have to go to court and have to go to trial and have to deal with proceedings. And then the outcome for that lead plaintiff will be the same for everyone else in the plaintiff group. So if the plaintiff managed to prove that the defendant was liable, all of the members of the plaintiff group will have the same result, and they will also get the same level of compensation as the lead plaintiff. So we can already tell the benefits that this saves a lot of court time, costs, and resources by doing it this way. In order to qualify as a representative proceeding, questions of fact or law that are raised have to be similar in all of the cases that are being brought together. We cannot do it if the defendant is someone else, or the facts are slightly different, or even if it's because it's usually for small disputes that these happen, for a small loss where it's too expensive for one person as a plaintiff to initiate a civil claim. So they elect to be part of a class action instead. Something might have happened like a bunch of customers were charged by a company $100 for a service that that company did not provide. So then 100 people come together and started a class action. But If something was part of it, like someone else got charged $500 instead, they automatically have different facts and they cannot be part of the class action because something different happened to them. So, the benefits of representative proceedings: group members can share the costs. It makes it much more affordable, especially as we said, because these are usually done for smaller claims. So, this is very important. It's a more efficient way of court dealings. It saves court time and resources. And people can pursue civil action they might have not been able to pursue at all on their own. So, this enables access. Furthermore, some law firms and companies and litigation funders often fund class actions for free. What they will ask for in exchange, though, is that if the plaintiffs do successfully prove the liability of the defendant, they will ask for a portion of the damages that they won from the case to be given to them. For instance, 10% or 15% of all winnings. For the individual as well, some other disadvantages we have to consider is that they may feel that they have loss of control over their case, because if you're not the lead plaintiff, you don't even go to court. You have no say in what evidence is used, what lawyer, how you want to present the case at all. And it can make individuals feel unimportant or that their voice isn't heard within the case. Obviously, a lack of fairness is also a potential issue. The case may not have been presented in its best light, and the outcome may have been unfair or wrong, but it will still apply to everyone within the plaintiff group. Importantly for the courts, multiple individual cases with the same facts are not tying up court resources, because we just hear it as one case and that decides the outcome for many, many people. However, there's less focus again on individuals within the courtroom. Now, we also need to talk about factors that need to be considered when initiating a civil claim. There are three that you need to know. The first one is cost. So when discussing this, you need to be talking about how the costs in the civil justice are really, really significant. They may discourage a plaintiff from initiating a civil claim, especially if that plaintiff, for some reason, has limited funds. So if you have a stimulus material, draw on specific facts contained within the stimulus, like, are they homeless? Have they just gone bankrupt? Have they just lost their job? Have they just had to pay a bunch of medical bills or for a house to be built? And they may not be able to afford these costs, and therefore they might not be able to initiate the case. There are some examples that you could potentially use. So, costs come from hiring lawyers. This includes barristers to represent us in court, but also solicitors to deal with legal documents, and they usually cost between $200 to $600 per hour. Jury costs are also incredibly significant because juries are not free like in the criminal justice system. They're completely optional, and the party that requests it generally has to pay for it. Pleadings as well. Pre-trial procedures as well add significantly to costs, also because we have to continue to pay for a lawyer and a solicitor throughout even pre-trial procedures. Another factor is the limitation of actions. This is where you look at if it's too late for the plaintiff to initiate a civil dispute, or it might soon be too late, discouraging them, making them literally unable to initiate a civil action. So limitation of actions they're all listed in the Limitations of Actions Amendment Act 2002. There are restrictions placed on the time within which a civil action can be commenced. There are some extensions, but individuals would need to apply for those with very strict criteria. So maybe you can bypass the limitation of actions period if the person that caused you very serious, life-threatening injury put you in a coma. So the reason you couldn't pursue your claim within 3 years, which is the limitation of actions period, is because you were unconscious in a coma. An example of limitation of actions would be that defamation cases can only be commenced within 1 year of the act actually occurring, so not for very long at all. Why do we have this? To make sure that the defendant doesn't have to wait around thinking that one day someone may take civil action against them and fear that. More importantly, the credibility of evidence is lost over time, and that poses a significant risk of unfair outcomes to either the defendant or the plaintiff or both. Evidence is lost and forgotten. Witness statements become um, slightly skewed from what they originally would have been, and there are risks of incorrect outcomes. And lastly, we have enforcement issues, and these are any complications that can occur during the application or execution of the court order. For this, we usually look at the defendant within the stimulus material and what their personal circumstances are. So, are they in jail and they're not going to be able to afford the damages the plaintiff will be awarded because they have no income in jail and no money? Are they overseas and it will be impossible to enforce an order to pay damages? And have they gone bankrupt for some reason or another and they're not going to be able to pay? For any of these reasons, again, a plaintiff may not initiate a civil claim because they know that that person will not pay them back and they will actually incur a financial loss by initiating the dispute. Now, the two bodies we need to know are CAV and VCAT in the civil justice system. CAV uses conciliation as its dispute resolution method, and its specific jurisdiction is disputes between consumers and traders and tenants and landlords. Specifically, they only help consumers. So the consumer must have initiated the claim, or the tenant must have initiated the claim against their landlord, and not the other way around. So they ensure that people are compliant with and businesses are compliant with consumer laws, their rights, and residential tenancies, and they help consumers when these breaches occur using free conciliation to help them. So questions will often ask you what's more appropriate, the courts, CAV, or VCAT for a particular dispute. The things you need to be considering if you're thinking about CAV or the question is asking you: first of all, if the dispute is within CAV's jurisdiction. If it is, that's an easy free mark and free point you can make. But as we just saw, many disputes actually don't fall within CAV's jurisdiction. Also, is the aim of the plaintiff they have limited funds or they wish to save money? Because if so, the conciliation they use is free. Whether the dispute is likely to settle. Conciliation is all based around parties coming to a voluntary agreement together. So if one of the parties is not willing to negotiate or even show up and participate in conciliation, the dispute will likely not settle, and there is no point seeking CAV's help, and this claim should go to courts or VCAT. And whether there are better ways, of course, to resolve the dispute. So some examples: CAV would be appropriate when parties have limited money, when they're willing to discuss the issue and attend conciliation and want to come to a solution themselves, when they want to preserve their relationship is because conciliation is relatively informal and is all based around that voluntary agreement. But it will be inappropriate if the case is not within their jurisdiction, or if parties or one of the parties refuse to discuss the issue, or if there is a power imbalance that may skew the final decision because someone has more power in the relationship between plaintiff and defendant. Now, VCAT jurisdiction is to hear smaller civil cases more efficiently and effectively. They help to reduce certain costs such as lawyers' fees compared to the courts, especially because lawyers are not really required for VCAT, and many people go on to initiate disputes within VCAT without any lawyer. They're faster than the courts as well. For instance, some of the lists, which detail some of the claims, in the civil claims list, for instance, 10 weeks was the average time to resolution, where in the magistrate's court, as an alternative, a civil claim may take up to 6 months to a year to be heard and resolved. It's also less formal than the courts, more quick, less costly, more efficient. But they're an alternative to courts that also provides a legally binding decision. When considering if VCAT is appropriate, First of all, look again, is the dispute within CAT's jurisdiction? For every question, it will be. VCAT has a very broad jurisdiction. Consider cost and time involved. Is it important to get the matter resolved quickly? If so, VCAT will be more appropriate. Consider whether the parties can resolve the dispute themselves. And if so, that might mean CAV is more appropriate. We don't need a legally binding decision, or another alternative dispute resolution method like mediation might benefit the parties better. Um, Whether parties prefer the formality of the courtroom. If they do, they should pick the courts. If the matter is large or complex, statutory interpretation may need to be conducted or complex laws may need to be applied, and this indicates that the claim should go to the courts. Also, because VCAT has a very limited appellate jurisdiction, and appeals can only be initiated based on point of law. So, law being incorrectly applied or the wrong law being used. And also the doctrine of precedent are some binding legal principles from common law that VCAT will have to abide by or not. Um, okay, so bringing it into more perspective, looking at specific points. For instance, VCAT is appropriate when a party wants to resolve their dispute through mediation or arbitration, because VCAT generally uses mediation and arbitration. They can use conciliation too, but they usually send parties to mediation to see if they'll reach a voluntary agreement, and if that doesn't work, an arbitrary hearing, which is like a less formal court hearing overseen by an arbitrator, where parties also have to present evidence, and at the very end, a verdict that is legally binding is handed down. When a party doesn't wish to go to court but wants a legally binding decision, VCAT is also very appropriate. We don't trust the other person to uphold the outcome, even if we agree upon it. We think they won't do it. If it's not legally binding, they won't pay us back. And if a party doesn't wish to have a lawyer or cannot afford to go to court or cannot deal with the time that will take, they may choose VCAT. However, although costs are usually lower, VCAT can still be very, very expensive depending on the list. Some waiting times are really long as well, depending on what type of dispute. When a case doesn't fit under VCAT's jurisdiction as well, we shouldn't pursue the case in VCAT. So you'll need to be able to compare the two, and here are some points there for you. You can compare their jurisdiction directly, what methods they use. VCAT, we said, uses mediation, conciliation, and arbitration. CAV uses only conciliation. VCAT fees are lower than the courts, but they are still kind of significant. CAV is completely free. However, CAV is not legally binding, and VCAT does provide a legally binding decision. This is our core hierarchy again. For civil, you'll notice you still need to know about appeals. And the other reason you need to know about is administrative convenience. So, administrative convenience dictates that the existence of the court hierarchy allows for civil cases to be distributed according to their complexity and seriousness, therefore dictating how much time should be spent on certain types of cases. This allows us to filter many, many, many less serious and less complex cases into lower courts, such as the magistrate's court. There, because they require a low level of expertise, because they are not complex, a large volume of cases can go through very quickly and be resolved without clogging up the court or leading to unfair or unjust outcomes. However, more serious and complex cases should be heard in the higher courts. There should be a lower volume of them because they're more complex, and therefore also more time has to be dedicated to them, such as the Supreme Court Trial Division. This allows courts to allocate their time, reduce delays, reduce backlogs, and distribute cases according to complexity. Again, you need to know what type of disputes are heard, both in terms of original jurisdiction and appeals in each tier of the court hierarchy here. For instance, magistrate's court is claims under $10,000, county court is above, Supreme Court is also above 10,000, but they differ in terms of the seriousness of the claims that will be heard in each. Your alternative dispute resolution methods you need to know, be able to define, talk about when they could be used. Mediation involves a third party called a mediator that listens to both sides of the dispute. They just facilitate the discussion, they're a facilitator, but they cannot provide their own opinion, and parties have to come to a voluntary decision on their own. Conciliation uses a conciliator who's actually an expert in the particular dispute issue. Again, they'll listen to both sides of the dispute, but they can actually provide suggestions of what the parties should do and what the solution should be to their dispute. Ultimately, it is up to the parties to come to a voluntary agreement, though. Arbitration adopts a third party, which is an arbitrator, who listens to both sides of the dispute, sees evidence, and then provides a legally binding decision similar to a judge, similar to the courts, just less formal and much faster. And there is a comparison table for you guys to use that's very, very helpful. Now, remedies is your last area. So first of all, being able to define remedies. A remedy is the means by which a plaintiff's civil rights are protected or corrected for the injury caused by a defendant. The general purpose of a civil remedy, you need to know both the general and the specific purposes, it's to restore the injured party to their original position as much as possible, which is the position they were in before any of the harm occurred. Now, the two types of remedies we have are damages and injunctions. And damages involve money, financial compensation, being paid by the defendant to the plaintiff when settling the claim. And injunctions refer to court orders ordering to either start an action to benefit the plaintiff, which is going to be a mandatory injunction, or prohibiting a particular action from being carried out or stopping it, which is a restrictive injunction. So the purpose of damages is to compensate the plaintiff for any loss or harm suffered. And this helps to achieve, again, that overall purpose of remedies, whereas injunctions aim to rectify or make right a situation caused by the person who has been found to be in the wrong. So make things right again. When you're answering these questions for what's more appropriate, damages or injunctions, and will they be adequate to adequately compensate the plaintiff, you need to consider the stimulus material. So ask yourself these questions. What sort of loss has the plaintiff suffered? If it's economic, damages will compensate that beautifully, paying back for lost salaries, medical bills, time off work, that can be quantified. These are quantifiable losses, and the exact amount can be paid back that they lost. So these are great. But if they're emotional, mental, reputation impacts, how can we quantify the value of someone's loss and suffering, depression, mental health issues, whatever it may be, and decide what is adequate for that person? We can't, and it's not going to correct what they've experienced or are experiencing. So, non quantifiable losses like emotional suffering, loss of quality life, they cannot be compensated. The person cannot be restored. But ultimately, you're looking to find if the money can fully return the plaintiff to the position they were in before any of the harm occurred. Now, when you look at injunctions, think about a restrictive injunction. If the purpose is to stop an action, has something damaging already occurred, and it's only stopping the defendant from causing further damage, but it's not going to address or reverse the damage that's already happened. Additionally, can that injunction stop the defendant from doing other things, such as out of malice? But more so, think about restrictive injunctions not being able to correct what has already happened. So imagine we're looking at a defamation trial. A restrictive injunction was ordered when the defendant was found liable that the journalist that posted the defamatory material cannot ever publish anything else about this celebrity that they defamed. However, they have already published something, the defamatory article. So damage has already been done, and even a mandatory injunction forcing them to take down the original article doesn't compensate for the fact that it has already gone all over the news, been shared on social media, and the person's reputation has already suffered immensely. That damage cannot be reversed. And again, does it fully restore the plaintiff to their original position? Okay, on to Unit 4. Again, you can see your key knowledge dot points. If you attended the July lecture, Unit 4, Area of Study 1 was the focus of that one, and there is quite a bit going on. I've tried to make it a little bit shorter so we can move through it in a realistic manner. Um, but the first thing we need to start with is the composition of Parliament. So Parliament is comprised of, at state level and Commonwealth, the lower house, the upper house, and the Queen's representative on both levels. However, the names and the numbers and the actual composition itself are quite different depending on what we're looking at. So the lower house is the house that forms government because the majority of members from one specific political party will become like the government party if there is a majority of one party, more than 50%. They will become the government party, and their political leader will become the prime minister. So this is the House of Representatives at Commonwealth Parliament, and upper house, and at state parliament level in Victoria, it is called the Legislative Assembly. But again, the party with the majority of seats in the lower house forms government. So the lower house is often referred to as the House of Government. Upper house, Commonwealth Parliament has the Senate, and the state parliament has Legislative Council. Usually, the upper house reviews laws more often rather than initiates new bills. Is usually the lower house that initiates bills, so they're often referred to. We often refer to the upper house as the House of Review. The Queen's representative, the Crown, has a very formal step called granting new bills royal assent before they come to pass, which is a fancy word for saying, on behalf of the Queen, they signed the bill saying it can now become law, and they have a right to withhold royal assent, but they never really do. So it's like a formal step that they have to sign off on legislation. Commonwealth level, this is the Governor General, and at state level, this is just simply the Governor. If you're confident and you understand the levels of Parliament, you will not be like this redhead. Once you get it, all of the content in Unit 4 becomes very easy. So if you're still finding it tricky in Unit 4, try to wrap your head around all of the concepts, and then everything should come to you. We need to know the roles of the houses. So the lower house, I've already explained how it forms government, but that's its key role. They usually initiate, debate, and vote on bills. They can also act as a house of review. If a bill, proposed law, is initiated in the Senate, they approve it, and of course, it has to go to the lower house and get approved there as well. But this rarely happens. They usually initiate bills. Why? Because the government party is in this house and they can pass bills with ease because they already have the majority of seats here. They also control government spending. So only the lower house can pass money bills. The upper house cannot. They can scrutinize government, so political parties argue with each other and who's better or not. They can initiate parliamentary committees to further investigate a bill, and how laws could be better improved in an area. And they form representative government representing the people. The upper house more often acts as a house of review. They can initiate and debate and vote on bills, but they're usually the house of review. As we said, bills usually are initiated in the lower house. Importantly, they cannot initiate any bills related to expenditure or money bills. This is the role of the lower house. They can also scrutinize government. They can also initiate parliamentary committees. But rather than forming representative government, they have a role in representing the interests of all of the states at Commonwealth level, and they have a role of representing all of the different regions of Victoria at Victoria state level. Now, the crown is represented by a governor um, representing the monarch. So we don't actually have a monarch stamping our legislation. They simply just represent the crown. Their role is to either grant royal assent, which refers to approving and signing bills, making them into laws and legislation, which is what they usually do. Like we said, they can withhold it, but this is very, very rare. They also can appoint an executive council. This is more so referring to the government party becoming the government party, the party with the majority of seats. So they get appointed by the Governor General. They also appoint federal judges for the High Court to make sure that it's not Parliament selecting them, so there's not like any bias in who is chosen to be on the High Court, and there's no corruption. And they can dissolve Parliament if they find significant corruption, meaning that re-elections will have to happen early to select Parliament all over again. Another concept that you need to know is the division of powers. So, first of all, we need to consider what lawmaking powers are. They're powers given to Parliament, whether Commonwealth or state level, to create laws. So, division of powers helps us to decide which parliaments should get which powers to make which laws, and divides them into exclusive, concurrent, and residual powers. You need to be able not to only define them and explain them, but also to provide an example of each. Now, exclusive powers, the word exclusive implies fancy, exclusive to the Commonwealth Parliament. So these are lawmaking powers held only by the Commonwealth Parliament. Some examples would include defense, currency, and border protection, all of the things that make sense to only be um, Commonwealth level, and things like import and export laws. Concurrent powers are shared by both the states and Commonwealth parliaments. That's why they're concurrent. They're clashing. Some examples include trade. So consider in if you live in Australia, according to Commonwealth law, you have to pay the ATO a certain amount of taxes depending on your income. This applies and is the same to everyone. The brackets are the same. But if you own a house in Victoria, you also have to pay council tax for the land on which your house is sitting in. So as you can see, taxation is a concurrent power. And both parliaments may make law in the same area which may contradict. So what happens then? And this is where Section 109 of the Constitution comes into play, which you need to know, be able to explain, and link to an example and explain specifically what happens when concurrent powers clash. So Section 109 says that when a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. So that very clearly says when there is a clash between state and Commonwealth laws in an area of concurrent powers, the Commonwealth law will remain operational and the state law will be abolished, but only to the extent that it clashes with the Commonwealth law and the rest of it may continue to operate. So a very key thing, and if it's missing from your definition and explanation to the extent of the inconsistency, if you're missing that, you will not get full marks. That's very important. It's not the whole law that's going to disappear, only the parts of the state law that clash with the Commonwealth law. So when you need to discuss the significance of Section 109, you will be discussing that Section 109 helps to expand the lawmaking powers of the Commonwealth at the cost of reducing the lawmaking powers of state law, because it expands Commonwealth law, because it clearly indicates its superiority in areas of concurrent powers. Lastly, we have residual powers. Residual just means everything left over, and that's exactly what the definition is. They are the lawmaking powers held only by the state parliaments, not by the Commonwealth Parliament. And they're residual because they're left over. They're all of the powers that are not mentioned in the Commonwealth Constitution, which are most things, therefore, by default, making them state parliament powers. This is the majority of lawmaking powers in order to keep in line with the purpose of the Constitution, which, when it was created to bring all the different states together, it was promised that it wouldn't take away power from the states, but allow them to retain it. Some examples: public transport. We have Mikey here, other states have something else. I'm not a pro on this. Education, everyone gets ATAR, but everyone has a different school system. We have VCE, we have HSC. Depends on which state you're in. And even criminal law is a great example because there's different laws and sanctions and time periods. The next thing you need to know is the Constitution and how it acts as a check on Parliament, and the separation, express protection of rights, and the role of the High Court in interpreting the Constitution fall under this umbrella term. So the separation of powers is not to be confused with the division of powers. That's a different concept. It's a principle established by the Commonwealth Constitution that ensures three main functions performed by the Australian parliamentary system are kept separate. So remember, separation of powers separates areas of Australian Parliament into executive power, which is the power to administer laws and manage the business of government. This is essentially performed by ministers. They are the members of parliament from within the government party, the party with the majority of seats, that the prime minister selects to carry out certain specific roles. So, Minister of Treasury, responsible for managing government funds and spending. Minister of Education, these are the actual executives. And they administer and manage the business of government. Fancy sounding, but what they do is they oversee that area they've been allocated to. Legislative power is the power to make laws. This is carried out by also members of parliament, but everyone in the lower house and everyone in the upper house, so that's a little bit different. And judicial power is the power to enforce law and settle disputes, which is carried out by judges. And this is the area that is really kept entirely separate, where we can see that executive power and legislative power clearly overlap because ministers are literally members of parliament and they are executives and legislatives all at the same time, but judges are kept completely separate. So that's very important because that means when we initiate claims stating that law is potentially unconstitutional, the judges will have no bias when making their decision if it goes beyond parliament's lawmaking powers or not, because they have no affiliation with parliament, and that's why uh, keeping specifically judicial power separate is so important. Again, please don't confuse separation and division of powers. This is a common feedback point on the examiner's report of students getting confused when a question asks them and they think it's the other thing. Now, express rights are explicit rights, rights that are specifically listed or entrenched within the Constitution. These are essentially our human rights protections, and we have only 5 of them. And you need to be able to give examples of them as well. And you should know their sections. You should have all 5 memorized because you could get a stimulus-based question about one specific express right. There is a possibility of that. So, the right to freedom of religion in section 116 declares that Parliament cannot declare one religion as the national religion. They also cannot interfere with practices related to religion or limit any religion's practices. The right to free interstate trade and commerce is section 92, which is self-explanatory. Trucks can go from Victoria to New South Wales to sell their products, and they don't have to pay any tax or any money to cross the border and they don't have any restrictions. So this is a big one for businesses and ensuring businesses do better in Australia, and there's no unnecessary like competition or restriction to their growth. The right to receive just terms when property is acquired by the Commonwealth is in Section 51, subsection 31. This refers to the fact that Commonwealth can take your property if they want to, I don't know, build train tracks there or a council building, but they will have to compensate you for that. So at least they will pay you. So don't know how much of a protection that is for people, but at least you get compensation. So that's that just terms. The right to trial by jury for indictable Commonwealth offences, Section 80, we know everything about this one, but remember that the Constitution only allows for jury trials at Commonwealth level, and state level legislation has to provide for it within the state's court hierarchies. Such as in Victoria, we have that in the Crimes Act, that you can get a jury for any indictable offence in Victoria. The right to not be discriminated against on the basis of the state where you reside in Section 117 allows for things like one person can go live in a different state if they're an Australian citizen, and they should experience no discrimination. They should be able to get a job and shouldn't be, not given a job because they've moved. They should be paid the same as someone else with their level of experience that hasn't come from a different state. They should be entitled to all the same things. If they need to work a job, they won't be subject to different requirements for that. Like, they finished a degree, but it's not accepted in this state because this state says you need to study for 2 more years. So these things don't happen, essentially. Okay, now how the High Court protects from parliamentary corruption. The Section 76 of the Constitution says that the Commonwealth High Court will hear disputes involving the Constitution and interpretation of the Constitution, and this prevents against any corruption or unconstitutional laws being passed. The High Court absolutely cannot change the wording of the Constitution, but they can conduct statutory interpretation and interpret the words within the Constitution to resolve disputes between states and Parliament, people versus Parliament saying laws are unconstitutional, etc. So, I think just as a note, so remember that the term is ultra vires. The High Court has the power to declare a law as being beyond the scope of Parliament's lawmaking powers, which is ultra vires, and then it will be abolished, and that law or act cannot operate anymore as it has been found to breach something in the Constitution, like an express right. Now, the factors affecting Parliament's ability to make law are its bicameral structure, international pressures, and the representative nature of Parliament. And these 3 you need to know. The bicameral structure refers to the fact that Parliament consists of 2 houses, an upper and a lower house. This is an important protection because it ensures that the bills that we want to pass are heard and passed by both houses. Because if it was just the lower house where we said the government party is, they have the majority there and they could just pass the bill, so they could pass any laws they want. But the Senate, unless it is a rubber stamp Senate with a very similar composition, which almost historically has never happened, the Senate usually has a completely different structure to the lower house, and the government party doesn't have the majority of members there. This ensures that they adequately scrutinize and review bills, and they are not just passing what the government party wants. So this is stated in Section 1 of the Constitution. Representative nature of Parliament refers to the idea that government represents the views and values of the majority of the people. We have a democratic structure, a constitutional monarchy, but it is a democratic parliament. So, in order to be voted by the public in the future and not having to fear being elected or not being elected again, government has to ensure they act to represent the views of the majority. So how Parliament is representative, you need to know this criteria. The fact that we have regular elections, meaning we can elect a different composition of parliament next time if we are unsatisfied with what they were doing in the period of the previous election, and they follow majority views. Generally, they want to please the majority of people because this is the majority of the votes, or they won't be reelected. What is the disadvantage of this is that often minority views and laws that help and are needed for minorities are neglected because they are not popular with voters, so Parliament doesn't think about them and do anything to initiate those bills. Additionally, controversial laws are perceived by Parliament to potentially affect their chances of getting re-elected, and they will often, even if they're very needed, try to avoid them and dodge them and not initiate those bills. Then we also have international pressures. These are just essentially parties and politicians, the pressure they experience due to international obligations or trade partners. So this includes treaties and declarations which Australia is a signatory to and therefore has committed to upholding the values set out within them. They're Australia's major international partners and things like international conflicts. So, an international conflict would be COVID-19 that resulted in the creation of a lot of different laws for isolation and quarantine. Major international partners would include countries like China, Japan, that we need to keep up a good relationship with, essentially. Now, we said courts can give meaning to the words in legislation. When a dispute comes before them where it's not set out clearly in an act what to do. So the reasons that statutory interpretation may occur is if problems occurred during Parliament's drafting of the act, such as mistakes, not taking future circumstances into account, not covering new technology. That's a very common reason that results in gaps in the law, and problems that occur during application. So that may include wording being too broad. Consider a word like reasonable being used in the act, like we looked at the accused rights to be tried without unreasonable delay. That would require statutory interpretation most of the time. Legislation can also be out of date, not updated. New technology may have come out that's not included. Words can be ambiguous or contradictory. There might be gaps in circumstances that haven't been taken into account or put in the legislation. And then what are the effects of statutory interpretation? You also need to know. A new precedent can be developed. If statutory interpretation was conducted, it means that there was no pre-existing law to apply. This means that common law is created, a new precedent, which is a legal principle developed through the resolution of a case by a judge that now becomes binding upon all of the courts that are lower within the same hierarchy. They will have to follow that precedent. If a similar case arises with similar circumstances, they will just have to make the exact same decision. But if the court is on the same level of the hierarchy or higher, they can change the precedent because they're considered to have more expertise. That means if a new precedent was established in the county court, the magistrate's court has no choice but to follow it. However, a judge in the county court or anywhere higher in the court hierarchy can change the precedent, make a different decision next time. Words or phrases in the act are given meaning and also clarified potentially. And the scope of legislation can be restricted or expanded. So, did we have a judge that's an activist and is going to expand the scope of the legislation to make it better? Or do we have a judge that thinks it's the role of Parliament to make laws and they will restrict the scope of legislation, saying it's not up to them to expand that legislation? So you need to be able to explain and give examples for these reasons, in-depth explanation. So then we look at those factors that affect courts and lawmaking, including statutory interpretation. So first of all, the doctrine of precedent. So that's referring to the fact that those Common law principles that are binding upon those lower courts exist, and they have this doctrine, meaning that they need to be followed by all those lower courts. This allows for consistency and fairness, ensuring that cases that are the same are treated in the same way. It also helps potential litigants to see, if I pursue this claim, how my case is likely to be decided, because there is a precedent pre-existing, so they can inform whether they should pursue claims or not. Courts can also develop law where Parliament has not yet created statute law. This may prompt them to fill in the gaps in their statute law, pass new acts enshrining common law precedent showing that they agree with it, or pass laws that contradict the precedent that the courts established to show their disapproval of it and therefore overriding the court's precedent. But it can also be inefficient because litigants have to bring a case before the court for a precedent to be developed. Only remember, courts can't just create law, they're only reactive. Someone with standing and a relevant case has to come before them for them to create a precedent or a new law in an area where it is missing from. It is difficult to know when a judge may also decide to distinguish a case and say they don't need to follow the doctrine of precedent because there are enough differences in this case that's now before them from the original case where the precedent was established. And it's also expensive and time consuming. Now, judicial conservatism and activism are opposite terms. Activism is likely to expand the scope of legislation if statutory interpretation is needed in a case and occurs, and conservatism is likely to narrow or restrict the scope of that legislation. So, conservatism is where judges demonstrate caution when making decisions and rulings that could lead to significant changes in the law. They think it's not the role of the courts to change the law. It is the role of Parliament. On the other hand, this maintains stability and leaves the lawmaking to Parliament, and it limits any potential contradictions between common law and statutory law. Activism is the opposite, where courts and judges lack to consider a variety of social, political factors and changes that occur over time when interpreting acts and deciding cases. This can allow them to recognize rights of people and communities, including human rights and their views, and they might make more fair judgments and expand scopes of legislation. But it can also lead to more appeals and disagreements and radical changes that don't sit well with the community or Parliament, and they might have to pass legislation contradicting that passed by the courts. Another one is the cost of bringing a case to court. So, taking a case to court can be very costly and deter individuals who may not be able to afford such costs or qualify for legal aid. And it's very difficult to qualify for legal aid. And courts are reactive. Again, they can only make law in cases that come before them. Benefits of this: we reduce backlogs, we reduce any frivolous, ridiculous cases or claims by having higher costs, and it also encourages parties to use other alternative methods and institutions that are available rather than just going through the courts. Unfortunately, it also deters litigants who cannot afford the cost of pursuing their case in court, and it can deter parties from pursuing appeals in particular, even if they receive an incorrect outcome. The requirement for standing is also very important. A litigant has to be directly affected by issues involved in the case for the court to be able to hear the case. This means that people who are really interested in advocating for the law on behalf of public interests or common good are unable to do so. And it also means that laws may continue to operate even if they're unconstitutional, and nothing will change because no one's initiated a claim to declare that law is unconstitutional. And potential improvements to the law are potentially lost as well. However, though, this makes sure that only people who are genuinely affected by an issue can bring their case to court, which is absolutely fair. If you're not affected by it, you're not affected by it, so why should you be able to? It encourages people not directly affected by an issue to also seek other avenues again of dealing with their issue. Now, the relationship between courts and Parliament includes the supremacy of Parliament, courts influencing Parliament, statutory interpretation, and codification and abrogation of common law. So we'll look at these. So Parliament is the supreme law-making body, hence the supremacy of Parliament. Their statutory law is superior over common law, with the only exception being the Constitution. They cannot change the Constitution without successful referendum, and they cannot pass laws that are against the Constitution. The High Court can just declare those invalid. But because Parliament is supreme, they can pass legislation that confirms or overrides court decisions, shows disagreement with them. And judges will have to follow that. They can also pass legislation to even change the jurisdiction of courts. Technically, according to the Constitution, they could technically do that. Courts, however, can influence Parliament. This is done through judges' obiter dicta comments, comments made by the way when handing down a judgment. They can state opinions that do not affect the outcome or judgment of the case, but potentially urge Parliament to update the law, for instance, or to change something. And they may listen. Then we have statutory interpretation, which we've looked at. Only courts have the ability to interpret statutes. This means that judges can clarify words and phrases within legislation or broaden or narrow the scope of legislation, another key aspect of their relationship. However, Parliament has an added role. They can decide if they want to codify or abrogate common law. So they can pass legislation that confirms or codifies a precedent set by a court, demonstrating support for legal principles. When they agree with a common law principle, they may update an act to reflect this and actually put it in the law, so that there is no doubt that that's what they want. They do agree with it, but they may also disagree with common law principles and abrogate them, get rid of them by legislating them away. Again, updating acts. Okay, so lastly, this is the shortest segment, Unit 4, Area of Study 2, because you are required to know recent Royal Commission, recent BLRC, and this stuff isn't on the slides because that's for you to know, so we're just going through the other dot points there. So we should go through this quick. Now, you're required to know the reasons for law reform. This might be a stimulus-based question. So one could be changes in societal values and attitudes. Something that we used to believe in is outdated and now is inappropriate. Changes in social, economic, and political conditions. So if we don't have COVID anymore, we don't need to wear masks and have a curfew and limit time we spend outside. Significant events or greater need for protection. In circumstances of war, people might be drafted to be part of the military and go to war, for instance. And changes in technology. The thing that comes to me for me was when, as cyber security picked up, Parliament had to actually release a lot of new laws pertaining to the area, and they even had to legislate definitions of terms like cyber attack, because people didn't know what the terms exactly meant, and it created a lot of havoc and confusion and panic in the community. The means by which individuals influence law reform include petitions, demonstrations, and court cases. Court cases, we know all about that. Someone who's standing can go to court and play a crucial role in getting a law declared unconstitutional and invalid, or raising the need for a law to change because it's inadequate in a certain area or outdated. Demonstrations are visual protests that we sort of see where people, march together, and we can physically see that, usually with posters, and they can use that to really lobby Parliament to change something. And petitions are written these days, usually electronic, request for Parliament to change law, that the more people you get to sign them, the more attention that they will gauge. However, there is no guarantee that members of Parliament will read your petition or do anything to address it, even if it has a lot of people signing off on it, and even though it's tabled in Parliament because they're required to be tabled in Parliament. They may still not do anything. So again, petitions, they're very simple, easy, inexpensive. They must be presented in Parliament. However, Because Parliament gets so many of them, there's no obligation to actually really read them or to implement the law reform. And influence might depend on who tables it and which party they belong to as well, and how much influence they have in Parliament. Um, Now, demonstrations unfortunately can be less effective if they turn violent, and their message may be lost. And they can also be hard to plan and organize, and may be impacted by factors such as weather. On the other hand, they attract a lot of social media attention and actual media, and they have great benefits in raising awareness. Court cases enable unclear legislation to be clarified through statutory interpretation. Judges are independent, so they make rulings on legal principles rather than political pressure, and therefore, court cases are more likely to influence some kind of law reform. However, individuals might be deterred by time and costs or may not have standing, and judges are only reactive, so only if a relevant case comes before them can they change the law. You need to know about traditional versus social media. So, what's traditional media? Things like newspapers, TV, radio. Their role is more so to examine, discuss, and inform people about legal issues and potential law changes. Now, social media is different. Social media is all about opinion. So, social media includes internet tools and platforms, but people actually communicate information and share opinions and comments. It can also connect people, and it can even reach government, unlike traditional media, because they are on social media. You also need to know about the VLRC. We know it's an independent, government funded organization. And yes, those two terms do contradict. It monitors and coordinates law reform activity in Victoria only at state level, and advises the government on ways to improve or update the law through investigations that are very comprehensive and that are very similar to royal commissions in a nutshell, because there will be a lot of financial investment. It will be time consuming. They will set key objectives. They will publish a final report when all of it is done with their recommendations, and summary of findings. They will have consultations with the broader community, experts, people that are affected by the issue. Um, and all of those aspects are very similar to what a royal commission does. So their strengths are they're able to investigate issues comprehensively, and because of their direct connection through the Attorney General, reports are automatically tabled in Parliament, and they also have a good bit of influence and likely to be taken seriously. However, Parliament has no obligation to commit to or follow any of the recommendations, and VLRC are also government funding, which may signify an underlying government agenda, potential corruption. Um, how Parliament may respond to law reform. So, first of all, they're the elected and supreme lawmaking body, meaning essentially they can easily respond to law reform, pass new law and legislation. They're also able to investigate the need for law reform, making them more able to respond. They can find out what the community wants and what is the best way to achieve that through the VLRC, through royal commissions, through parliamentary committees, or even just due to the fact that they are representative government. And Parliament can respond quickly to a need for law reform. Now, court's ability to respond is a bit different. Um, Judges can make decisions without political pressures, and they have no connection to Parliament, so um, they're more likely to respond to the need for law reform if it is needed. They can also declare legislation ultra vires or invalid beyond the scope of Parliament's lawmaking powers, and they can highlight problems and raise awareness through their obiter dicta comments to Parliament to get them to be aware that there is an area of law reform they need to get on top of. Okay, lastly, we're on to our study tips. So the first thing is breaking down questions, and I want you to make sure you don't skip this step and you address your questions properly so you can get all the marks and ensure your success. So first of all, look at the task words. The task word tells you how you need to craft your answer. So for instance, evaluate means you need to write about strengths and weaknesses. Discuss means you need to talk about pros and cons. Identify means you just need to state the thing that it's asking for, and you don't even need to write a full sentence. 3 marks. Now, content words tell you what section of the study design your answer needs to be about. So, for instance, separation of powers, it tells you what you need to answer about. Limiting words tell you what not to write. So, for instance, if a question says one example, there are always students that are like, oh, yeah, this example I did, it's not so good. So I just started extending into a second example. No, because if there's a limiting word, you actually don't get marked past the point where your first example ended. So, where you started your second example, and even if that one's perfect, you ignored the limiting word and you don't get any marks in that area. And then also mark and time allocation. So in the end of year, you approximately get 1.5 minutes per mark. So use that timing when you do practice exams. We see an example here. Discuss two responsibilities of the legal personnel in a criminal trial for 4 marks. Okay, so I have 6 minutes for this question. I need to discuss, provide advantages and disadvantages, only two responsibilities, so I make sure I only have two mini paragraphs, one for each responsibility, and I just need to plan and make sure that the roles of legal personnel I chose, I have enough to write about, so I don't have to go into a third example that I won't even get marked for. And the responsibilities of legal personnel is the area of study I need to refer back to. So, okay, I chose judge and I chose, I chose from legal personnel. I chose the overarching obligations they have to abide by and the notion that they have to represent the case in its best light and allow the plaintiff to allow the party their representative to still retain party control over their case. They might inform them and advise them, but it's still up to them to decide what they want to do. And that's going to be enough for my 4 marks. Um, okay, so that's breaking down some of the most common task words for you and what you need to achieve. For discuss and evaluate questions, you should always have a little introduction statement and a little conclusion statement. Especially for any question that is 6 marks and above, it is an expectation that you have those if you want to get full marks. And this is a very easy area to lose or not lose marks. To what extent? Questions, you must state the extent. For example, to a large extent, to a moderate extent, to a low extent. And that needs to go first as your little introduction statement when you're starting. Compare questions need to be about similarities and differences versus questions that ask you to distinguish are only about the key differences, no similarities. And that's what's different with them. Signposting is needed and is expected, especially if you are comparing or distinguishing. If you don't use words like whereas, on the other hand, distinguishing words, you will lose marks for the question because you are not indicating that you are talking about differences. It's actually important to remember this. And signpost your answers, paragraph them. Examiners get so upset and always complain about students not signposting, not separating different ideas into small mini paragraphs. These are all the things that are expected of you. Showing you the time limits. Sorry, guys. This shows that your 10 marker you should only spend 15 minutes on. So, I used to do my exam in order, but if you think it's beneficial for you to spend a bit of your 15 minutes reading time planning for your 10 marker, and once your writing time starts, just doing the 10 marker first, that would be a great idea. And that way you are probably using your reading time wisely because you've read through the entire exam, you've thought about the questions, but you plan for the 10 marker so you can get it done in those 15 minutes. Now, how I suggest you study for the exam. You need to view it as a process. The first step is knowledge. If you haven't revised and if you don't remember all of your content, there is no point in doing practice questions. You won't be able to do your best in anything that you do, will be time wasted. So even though it's the most annoying thing, you need to sit there and whatever works for you, flashcards, writing and reading back your notes, reading your textbook, doing practice, doing watching those Edrola videos if you've got Edrola, whatever works for you in terms of memorizing everything, that's what you need to do first. And everyone has a different method. I just liked I wrote my notes throughout the year, hand wrote all of my notes. I get really good memory from writing things down, and I just used to regularly read my notes again. I found that effective, but I know things like Quizlet, flashcards, talking about legal concepts with friends and family are all great methods. Then you need to make sure you understand and apply the content after that. So to check your understanding first, try to make yourself do one-page summaries of, say, an umbrella term, a topic in Unit 3 or Unit 4 to see if you really do understand and remember everything from what you just tried to memorize and learn. Then you need to apply to timed practice questions, hopefully from past exams. It is not as valuable at all to do textbook questions. They are nothing like exam questions. They're a lot easier in legal studies. And so are most providers that I've seen. Not all, but some providers do have easy exam compared to VCA Legal Studies past exams. So that's really it in terms of studying for legal. That's all it is. But you do need to find what study technique works for you. So some of the study process techniques I'm going to outline for you for knowledge, step 1 of your exam prep, are as follows. So flashcards, I already mentioned, one-page summaries. That's a really fun one, and you could do mind maps as well. Quite time efficient and really great for consolidation. Going through the study design, just looking at each dot point and seeing what you remember, and then checking if you really remembered everything. Again, explaining concepts with family and friends, timed practice exams and examiners' reports, even just reading examiners' reports and the points that they raise and trying to remember things that you didn't remember before is revision. Importantly, practice questions, brainstorms, and using your teachers and getting clarifications and asking questions as well. Now, but first, the key thing really is have your knowledge, then do your application, your practice exams, and do a lot of practice questions. The more you do, the more confident you'll get. There is no set number of how many exams you should do. I can't give you that at all. It depends on each student. But the answer to that is when you get to the level that you're satisfied with, then you've probably done enough, and then you could still do a little bit more. Um, do 10 markers. At this stage, try doing a 10 marker once a week as well to practice them, practice structuring them. They're all different. Each question is different. So just get accustomed to it. They're tough. Just try to do them regularly. All right. Thank you guys so much for coming along. I hope you found this really, really helpful. And I want to wish you all the best for the Year 12 Legal Studies exam. All the best, guys.